o'clock, and the code board for the city of Tarpon Springs is now in session. Bobby, would you call the roll, please?
Ms. Wade?
I'm here.
Mr. Perfidio?
Here.
Mr. Weeks?
Here.
Ms. Telliar?
Here.
Ms. Archer is absent. Mr. Rollinston?
Here.
Dr. Matea?
Here.
Ms. Eisner?
Here.
Mr. Ogle?
Here.
Please your roll call.
I'd like to remind everybody, please turn your cell phones off so that we don't have an interruption from that. And if you'll stand, we'll have an invocation and a pledge. Our Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order of the to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board is as follows. First, the city will present its witnesses and exhibits, after which the alleged violator is able to ask the city witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits, and then the city can question the alleged violator's witnesses. After both rounds of testimony on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we'll have all potential witnesses stand up and be sworn in by the secretary of the board. I think somebody just came in. Just remember to turn your cell off. So if you're going to testify, you need to stand, please, and Bobby will swear you in. Anybody that's going to speak.
Okay, raise your right hand.
Yes.
Ready?
Bobby
Do you
will
swear
swear
the
you in.
testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You can be seated.
All right. For the board members, notice on your agenda there's a bit of a change. Those items listed as 1, 9, and 10 are not being heard today. We'll start with new business, listed as item 2 on your agenda, and it's case number 23-81111, excuse me, 23-8000019, the Palms of Tarpon Springs Condo Association with the address of 600 Haven Place, Tarpon Springs. If anyone is here for that case, I assume you're here for that one?
Yes, we also have a number of them.
Thank you. So the city's going to present their case, then y'all can ask questions, then you can present your case. And we're going to accept the evidence into the record if there's no objection to that. Thank you. Bobby will do that.
Perfect, thank you.
You could.
On February 7th, 2023, I inspected the property located at 600 Haven Place due to a citizen complaint. This is a residential townhome and condo development with a majority of the units being privately owned. However, the property is owned by the association. On March 4th, 2022, a fire occurred and severely damaged 8 residential units: 708, 710, 712, 714, 716, 718, 720, and 722, which were all located in a single building together. Due to the extensive damage of the fire, the electricity and water services were disconnected from the building and have remained unconnected since, almost 12 months. Since the fire, there have been no efforts to repair, replace, or do any kind of remediation to the affected units by the property owner, which leaves all 8 units unsafe, unlivable, and unable to be repaired by the unit owner's insurance if they have any. The property owner is responsible for everything on the building and in the units from the drywall outwards, and everything from the inside of the drywall into the units is the responsibility of the unit owner. Unit owners cannot repair the inside of their units until the outer portions have been remedied, and with there being no electrical services for almost 12 months, leaving no ability to circulate air in the units that were wet from the fire hoses, the interior units continue to deteriorate. The property was posted with a notice of violation with a compliance date of February 21st, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on February 21st, 2023, and found that no efforts had been taken to bring the property into compliance. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by utilizing licensed contractors with proper permits to repair, replace, and/or remediate all 8 units to the full extent of their legal requirements. All permits are to be applied for, approved, issued, and have final inspections to deem the units safe. A hearing notice was posted on the property on February 22nd, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until April 6, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $250 per day beginning on April 7th, 2023 until the property is brought into compliance. Exhibit 2 is going to be photographs of what the units look like now. And on several of the photographs, you will see that they are not secure. There are several open access windows. Plywood's not put onto the door properly. It's just leaning against the building. Still a lot of fire damage that just, again, has not been touched. Exhibit 3 is going to be the notice of violation, along with the certified mail receipt and the signed signature card. And the notice of violation and the notice of hearing were also sent to 2 different addresses to make sure that we got a hold of the condo association. The affidavit of posting for the notice of violation, the notice of hearing, along with the certified mail receipt, and the affidavit of posting. Exhibit 4 is going to be the property appraiser that shows that the Palms of Tarpon Springs, the Condo Association, Inc., is the owner of record. And the same is also on the Pinellas County tax records. Sunbiz is also included for their administration. And Exhibit 5 is going to be an email that was received on Tuesday, February 21st, the date of compliance. It was from the association saying that to date, they have completed the engineering plans for the site and plan to start demolition as soon as permitted. Unfortunately, due to issues with the insurance adjuster, there have been some delays, but they plan to have that straightened out. They asked for an extension, but due to the circumstances of the houses being unfit and being safety issues, they were not granted an extension at that time. And that is all I have right now.
Will you identify yourself, please?
Of course. Robert Todd, counsel for Palms of Tarpon Springs Condominium Association.
So you're for the association and not for the owner of the...
The individual unit owners are the individuals that were affected. They own units within the condominium structure. The condominium structure, the common elements is whom I represent.
Alrighty, do you have questions for her? Just questions at this point?
Yes, of course. And this is all going back to basically the formalities of the notice. One of the main contentions, and certainly a lot of the documentation you provided speaks for itself, but one of the main contentions, I believe, of the impetus for this hearing, I believe we're dated February 14th with a compliance date of, is it February 28th?
Yes,
Okay, so the association's given effectively 2 weeks to resolve the issue presented. The statement here is that no work has been done. Effectively, the association has taken no action
Are
in
you,
relation.
are you asking her questions?
Is that true?
what is exactly is the question?
Your statement is the association has taken no work, no effort to resolve the situation presented in the city's case.
Correct.
Would you consider undertaking engineering plans to be work on behalf of resolution of the issue?
It could possibly be, but I have no documentation of such.
Okay. We will call witnesses to that effect today, so that would be wonderful. Would you consider consultation with the fire marshal to be efforts taken in resolution of the issue?
Possibly.
Possibly. Would you consider consultation with the police and fire departments necessary for investigations of arson and other inquiries regarding criminal activity to be necessary in undertaking a repair of those premises?
No.
No. Consider it to be a precursor for the association to take action in repairs before the fire department and the police department concluded their investigations?
That is out of my realm. I cannot answer that.
I'm just trying to get to the bottom of whether or not the assertion that the association took no action is accurate, as alleged in the initial complaint made against the association. So I'm trying to bring to bear all of these items that have been done, and we do have a witness that'll come forth later on behalf of the association to show all of the things that have been done by this board of volunteers. But as it relates to the documents presented, I do see here the photos taken, they're dated March 8th, 2023, is that correct?
Yes.
Did you perform a photographic intake of this procedure, or of this facility prior to March 8th, 2023?
No.
No. Did you review the premises prior to March 8th, 2023?
Yes.
Prior to March 8th, 2023, when these photos were taken, was there any change to the premises before March 8th, 2023 to March 8th, 2023?
No.
No.
There's been no evidence submitted regarding that. I think it's irrelevant.
I disagree. They submitted photographs indicating the pictures that affected the association. That is the basis for their
But
exhibit.
our case is only based on this, so anything prior, we are not allowed to assess. We don't have evidence of anything before that, so I'm going to say that's not evidence that we can accept at this point.
Evidence
the
during the
question
course of your
doesn't relate.
investigation? Okay. During the
Another
course of
tack.
your investigation, did you review the premises and see that any action had been taken on the premises during the course of your investigation only?
Nothing has been completed since I started my investigation.
Okay. So it's your testimony today that there's been no work done to the premises since February 14th, 2023?
Correct.
Okay. Just one last question, and you're going to have to help me here because we're going to have the opportunity to call witnesses shortly, I presume. Thank you. One last question in relation to your investigation. Do you believe that the 14 days afforded to the association to rebuild the premises is a reasonable timeline to perform the activity?
Due to the property being a hazard at this time, yes.
So 14 days to reconstruct a 2-story, 8-unit building is a reasonable time frame?
It would be reasonable if it was made safe,
Okay.
but I have had no contact from anybody at the association to even speak regarding that.
Okay, so just to clarify what we're dealing with, the concern of the city is securement of the premises from access or reconstruction? I'm just trying to make sure what we're here to talk about today.
It would be both. It needs to be safe,
Okay,
and it needs to be repaired or replaced.
I agree with you completely. So to that end, are the timeframes that we're discussing in relation to your demand within the 14 days related to the safety or the reconstruction of the building?
It would be both because it has been unsafe and it has been in this condition for almost 1 year.
But we can agree that it's impossible to reconstruct a building of that nature within that period of time, can't we?
She's not asked you to do that.
You need to give him an opportunity to answer the question. Thank you.
Can you repeat the question, please?
You would agree that it is not possible for the association to reconstruct the building within the time frame provided, 14 days?
I'm not a builder, so I can't say it cannot be.
Okay, well, I think we both know the answer. No further questions at this time.
Would you like to present your case?
I would love to present some witnesses and my case if that's the proper time.
And just want to make sure all the witnesses have been sworn in. Thank you very much. And you just need to say your name and your address when you come to the microphone.
Sure. Yeah.
And Ms. Chair,
Who wants to go first?
But he's giving it as testimony evidence.
Right.
So very briefly,
I have a question, sir. Who do you represent exactly?
Palms of Tarpon Springs Condominium Association Incorporated.
You represent the corporation of the association?
Yes, it's a condominium association. These two ladies are volunteer board members. They were elected by the membership to serve in the non-paying position as board members of the association. They're taking time off of their work here today to come in and to address this fine committee and to hopefully resolve the situation.
Have you been in this position for a period of time or a recent hire?
I've been with Palms of Tarpon Springs, I think it's like 12 years now. This is the first time a code enforcement issue has actually come
I
up.
didn't ask that question.
We're going to hold off on
My question
questions.
was, how long have you been representing this association?
12 years, as I said.
12 years.
Yes, sir.
So we can assume you're very familiar with the association and its ongoings.
Well, for what they give me to do, I'm familiar with what they give me to do, sir. Yep. Okay, so since we are moving on to case in chief, let me know, do you want me to provide an opener or just go right into witnesses? I'm not sure how you guys handle it.
That's completely up to you. Under the rules of procedure, you can present your case with an opening statement, or you can
Great.
just go into presenting
I'll be
witnesses.
brief. I know there's a lot of other cases behind us, too. The situation that we're presented is not one that we are enviable to have. The association has been tasked with resolving a situation that is very large. The fire that struck nearly a year ago today was thankfully something that didn't involve a casualty. There was a casualty event, though. The building burned down. The association undertook substantial damage. A number of individuals were put out on the street, quite literally, as a result of the building being burned down. The association at that time was tasked with the very onerous mission of undertaking a rebuilding of the structure for which it had to go through not only insurance, but to obtain the necessary permits, plans, engineering, reconstruction, everything relevant to building the apartment building from effectively scratch, except worse, because at this point in time we were dealing with not only a fire, we were dealing with a police investigation as to the nature of the fire, who to hold guilty for that position, and what to do next. So the association fully agrees that it is in the position to undertake the work being demanded by this committee. It does not shirk that responsibility. It does not intend to say that that's not a responsibility that it does not seek to perform. Security of the premises, number one concern for the board, and it's my understanding, and you will hear testimony to this effect, that the association has undertaken remediation of the premises in light of the demand received by this board. In fact, that premises were remediated, secured, and additional actions taken to make sure no one could get into those premises subsequent to notice that they were made a danger and open to the public. So steps to secure the premises have been taken, and steps have been taken to ensure that reconstruction of that building can happen as soon as possible. And we're going to present all the evidence necessary to show that today, and we hope that the board takes that into consideration, allowing us ample and necessary time to reconstruct the premises. And I'm going to turn it over to, who wants to go first? we're just going to indicate to the board, and I'll lead you, what efforts have been undertaken, what you've done in your position as a board member this time. Very simple stuff. Please.
While she's getting ready, we feel horrible for all of you if you were the ones involved in that. We know this is a really tragic thing for a lot of people.
You gotta wait until you come up, please. That means
I'm
stop.
sorry, ma'am, by the rules, we can't let you speak right now, but you'll get a chance.
Yes, Ms. Wade, they did sign up to speak when we're done.
Okay.
I'm so sorry.
Please state your name for the record.
My name is Rachel Spengler, 746
Speak in the
Haven Place.
I
microphone.
need you to
Please.
bring the mic closer for you. Thank you.
My name is Rachel Spengler, 746 Haven Place. I'm the Palms of Tarpon HOA president.
How long have you held that role?
January, beginning of this year, officially.
How long have you been on the board?
It will be a year at the end of December.
Were you on the board at the time this event occurred?
I was.
When were you informed that a fire had taken place?
Immediately when it occurred.
Okay. And what steps were taken after you were notified that a fire had occurred on the premises?
Fire department was called by a resident. I was notified. We also notified our property management company at the time.
Okay. And after the flames were put out, after everyone was secured as safe, after there had been determined to be no additional need for the fire department to be actively working on the premises, what did you do next?
I was instructed by the fire department that the properties needed to be secured, so I contacted a restoration company and worked with them until late hours of the night to secure the property.
And was that within a couple of days? How long was that after the fire?
We worked that same day until 1 a.m. and they had officially finished.
Okay. How many days did it take to secure the premises?
It was secured within a matter of hours after the fire happened.
And was this event witnessed by members of the local fire department?
They did come back the following day to continue their investigation. So they did see that we had boarded any broken windows or any lower level access with plywood.
Was any indication made by the fire department that further security of the premises was necessary at the time?
No.
Have police officers been to the premises?
Yes.
When?
They were there the next day along with the fire marshal, and they were tagging and bagging evidence at that point.
Why were they tagging and bagging evidence, as you stated?
They believe that the fire may have happened from a water meter that was recently activated by a new owner, and it was a battery explosion or some kind of misfire that caused the fire to occur.
But you weren't aware of anything to that effect actually occurring? That was just one of the reasons why the police were investigating, is that true?
Correct, yes.
Okay. In relation to the police investigation, were you informed of when that concluded?
I have not been informed from anyone as far as the investigation and what that result was.
Has the fire marshal report been provided to the association concluding the investigation by the fire marshal?
Preliminary report only, nothing conclusive yet.
When was the preliminary report provided?
I think it was,
Was there a time when you remember that the preliminary report was provided?
I believe it was at the end of May, or I'm sorry, beginning of, right here, May the 4th was
Well,
provided.
and rather than going off of the timeline I've created, was there a reason why you knew that the fire department had submitted a report in May, as you mentioned? Did you receive a copy of it?
I did,
Was it a preliminary or final copy?
preliminary.
Have you received a final copy making the determination by the fire department as to the cause of the fire and the resolution of the issue?
I have not,
So it's still outstanding, safe to say?
yes.
Okay, let's move on to the association's work.
So, we had a, Condominium Associates was our former property management company. They submitted a timeline of things that they had been doing since the fire occurred, and it was probably within a 2-month time period. They had submitted charges to the board asking us to pay over $10,000 for work that they have done on the property. The board was very concerned because the buildings sat untouched, nothing had been done, but yet they were trying to submit charges for work that was completed. So at that time, the board decided to seek out a new property management company, and we interviewed 5 different companies. We asked for how they would handle this, when could they start. That was our first focus with that. We did find a company willing to step in and take over the process.
And when did that happen?
That was August, early August, when we found out that they had submitted charges, and that's when we decided that we would pursue other property management companies at that point.
Let's back up, because there's a little bit of time missing there. We went from the fire in March to the investigation by the police, and now we're talking about August. So what happened in the time frame between March and August? Was work being performed in that regard to remediate the premises, or submit it to insurance, or get contracts, or get bids?
So at that time, our property manager was handling everything. The board was not involved at that point at all. And the charges, the itemized charges that they had submitted were for phone calls being made to different engineering companies, contractors, to try to get people to come out and complete work.
So would it be safe to say that you were relying on your agent to perform work in obtaining bids, contracts, engineering plans, everything necessary to resolve this issue subsequent to the fire and before August?
Yes.
Okay. You said that you fired your property management company in August and moved to a new one, is that correct?
We didn't officially fire, but we were looking at that time in August because we were already under contract, and we had to fulfill the contract before we exited.
When did you officially change property management company?
December 1st.
December 1st. Has that property management company been able to cause the association to move forward with remediation of this issue?
Yes.
How?
We have contacted our HOA adjuster. We've had them in contact with the HOA adjuster, the LHR representative, who's a contracting company that's supposed to have secured bids for us and moved the project forward.
Well, let me stop you there. Who's LHR?
LHR is a company that is an Associa company, which Associa is our new property management company, effective December 1st. We were referred to them to have them handle the fire project.
And what role do they serve?
He is a lead or a VP in estimating, so he will secure the bids to move us forward with the completion of the project.
So would it be safe to say that you have a professional agent necessary to secure bids to proceed with getting the project started?
Yes, we do.
And that would be LHR.
Yes.
And what date did that occur?
We signed an agreement with them at the end of August.
Okay, so the end of August, LHR came into the picture. Therefore, where does the association stand now? We got the notice for this hearing in February. Was anything done between January and February 14th?
I filed a complaint with the Department of Insurance because we have been unsuccessful at getting the HOA adjuster to respond to our emails and our inquiries with what we can start and what we can't. They did issue a payout, but because there were certain...
Sorry about that.
Check your phones.
That giving me the business.
I'm sorry, start that again. I got.
Okay, so you were talking about LHR in August.
Yes.
That was proceeding with providing all of the necessary steps to get the bids secured, to get the work performed. But then over winter, insurance was
Unresponsive.
Unresponsive, okay.
So I contacted the Department of Insurance and filed a claim, and then that immediately, or complaint, that immediately got the HOA adjuster's attention. She called me and informed me that she was changing her entire stance on the project, meaning what we had agreed to was as long as I secured a demolition estimate, we could begin the demolition. And that was supposed to be done back in October. We were ready to go. And then now she's changing her stance, saying that she needs estimates for the entire project. And the reason why is she's saying that there are some things left out of their RIMKIS estimate that the insurance company secured that should have been included but weren't. And we're close to policy limits, and she wants to make sure that she can issue additional payments for those additional line items that weren't initially done on their end. Because our contractor is saying, you've missed X, Y, and Z, you've paid them out, we need to get compensated for these missing line items. So I called LHR and I presented the change in stance as far as what now we were required to obtain. And that's when he immediately contacted engineering. We needed to get the engineering, we needed to get shoring, we needed to get the architectural, we needed to get construction. So that's where.
And since that time, have you secured any documents that we can submit as exhibits relative to the association's physical work performed on this project? Have you received anything from engineering? Have you received anything in relation to any of the projects that have been specified by LHR or paid for to allow the association to move forward with this action?
Yes, I've paid for engineering plans, and I do have engineering plans in place.
Would the board like us to submit the engineering plans as an exhibit?
This is for the rebuild
For the demo and the
or
rebuild?
for the demolition? Because
No,
as
no.
far as I can see, we're only asking for security and demolition, I think, not the rebuild.
Well, we're going to be a step ahead of you then, because let's submit them anyways, just so that the board can show how, can see how committed we are to moving forward with the resolution. Are you familiar with these documents that I hold in my hand here?
Yes.
Am I going over above and beyond on the rules of evidence here? Can I just submit?
So, as long as the city prosecutor does not have an objection to the evidence, you can submit it, and it can be retained by the board. And I would also let the board know that the remedies that are provided for in the notice of violation include repair or demolish, and then bringing up to the Florida Building Code. So either repair or demolishment with respect to the violations that are currently there.
It's not reparable. It's going to be demolished.
Thank you.
Only 4 are being demolished, the other 4 are being renovated.
Okay. 4 and 4?
It's a row home.
I know
Yeah,
where it is.
so
I've been there.
4 are definitely need demolition, and the other 4 are renovation only.
Okay.
So can you describe the exhibit that I've given to you now?
These are the engineering plans.
And when did you receive these?
We received those this week.
When did you request them?
We requested those, well, I officially signed a contract for them with the engineer on December 5th.
Okay. And so from December 5th until now, for you to receive the plans? Is
Yes.
that accurate?
Yes.
Okay. And do you see any reason why the association would rebuke or otherwise not accept these plans? Of course, you're not an architect or an engineer, but any reason why the association would be unable to proceed with or accept these plans as drafted?
No.
All right. I'd like to submit the plans for engineering, composite exhibit A, 3 different sets to the board.
We'll pass them down, and Bobby will enter them into the record. We have no objection.
Yes.
I do very much
Thank you.
appreciate it.
Thank you.
So,
If there are 3 sets, let's do it in 3 spots, so it'll take you quicker.
so that's where we stand now.
Oh, I see, it's one each, 3 units.
Are there 3 sets?
No, there's 3 sets.
Put them at the other end to make it quicker.
They are 3 different documents, but they all look relatively the same given the nature of the building being homogeneous. Okay, so that's where we are today, I would say. Where are we going tomorrow?
So we, as a board, have decided that this LHR company, this 2-month, 3-month lag of providing us with these bids is a little ridiculous. Sorry for being unprofessional, but I just wanted to make sure that we get to this timely. So the board did start to interview new companies to take this over. We did find a company who said he would immediately step in and he could start applying for permits and move forward with the demolition plans that we have as of today.
As it relates to the securement of the premises, I would say your major concern as well as mine, is that accurate?
Yes.
What steps have been done to secure the premises since the notice of the code enforcement board hearing?
I had our maintenance man go back to the properties that were affected and had him reapply the plywood that was leaned up against the buildings and just do a walk around for a thorough inspection in case we missed anything. There have been police and fire personnel in and out of those buildings since it was secured the night of the fire. So that probably would explain why some of those things were taken down. but they have all been officially put back in place to secure the property.
And when was that done?
That was done this week, Monday.
Would you be adverse to undertaking further securement upon the direction of code enforcement or this board?
Absolutely not.
Would you say whatever it takes to secure the premises?
Absolutely.
I think that's good. Do you have anything else you wish to add?
No, I do not.
Questions from the?
Yeah, yeah. Sir?
Yes, please.
I'm just sitting here listening to this, and it seems like my
Dr.
humble
Mateo,
opinion,
let's
there are
keep
5
with our normal
entities
order.
involved in this. There's the association, there's the property manager, there's the insurance company, there's the fire department, and the police department. Now, in this whole group of entities, if you would, what's the holdup? Is it the insurance company? Is it the fire department? Is it the police department? Is it the association? Who's gumming up the works so things can't move smoothly?
Would you like me to address that, Ms. Kardash, or is this part and parcel of the?
This
time?
is, so the board at this point has the opportunity to ask questions of your witness the same way that you could ask questions of the city witness.
Just making sure
Okay?
I didn't know where
Yes.
we were. Please, I think that's a very reasonable question.
So it started with insurance, when they changed their stance on what was being required. They did that to us twice now. That's why I tried to file a complaint with the Department of Insurance. Once that got resolved, they were okay with approving things, but they needed more estimates, which we were not originally informed that we needed the entire project to be completely finished before they would even approve demo, because back in October, we were advised, hey, you can start this immediately once you secure your demolition plans.
Are we going to go ahead and ask questions now? Were you complete, has your case complete?
My
Well,
witness.
ask-
I would suggest that you ask any questions of this particular witness before moving on to the next.
Okay.
Yes, sir.
Yes, thank you. 3 questions. Your insurance policy was for replacement value?
Yes.
Your insurance company, not your insurance company, but what date did you initially file a claim with your insurance company?
The day that it happened.
The day it happened. And have you satisfied the insurance deductible?
They were going to take that out of our initial payout.
Okay? That's all.
He's got a question now.
I got a couple of questions for you, ma'am. So the day of the fire, you said that at the time, your current management company, they were handling everything?
Yes.
They submitted the claims to insurance, they were doing whatever it is they did, and that 6 months later, you became aware of charges, and you guys weren't happy with them and you moved on, correct?
Correct.
So, in 6 months, they were just left to their own devices. The board had no idea where things were until you got a bill?
Yes.
Okay.
I believe that's it.
I'm sorry?
I'll get her on redirect, but please.
Is anybody currently serving on the board a resident of one of the destroyed units?
Yes.
Okay. That's all.
I have a few questions. Okay, the pictures that were taken by the inspector are dated 8 March 2023. Which was yesterday. Yeah. I have a talking calendar. No. But anyway, and in that, it shows that there are unsecured plywood, et cetera, open, but yet the statement is everything secured. Obviously, that's not true. The other question I have is that you mentioned about the preliminary report regarding the fire, whether it's arson. So there was no forward movement to find out, hey, obviously the preliminary report didn't say it was arson, based on what I'm understanding here, but nothing was pulled, to further pull. And the other thing is, when you talk about your agent did this, okay, it's still the property owner's responsibility. You guys got to push on that. So that's just, my understanding of this. And if I'm wrong, by all means, tell me.
I have pushed on it. I'm given many, many hours of my personal time to do this.
I don't doubt it, but I'm just saying it's still the association's, the property owner association's responsibility, regardless of who your agent is. And that's all I have.
No one is trying to discredit you in any way. We understand how very difficult it was for you and is for you. We also don't want to cause any further difficulty for you, but we do have concerns to make sure that the property can't be harmful to someone else. So we have to make sure that it is secure. And the pictures that were given to us don't indicate that. And they were just done yesterday.
Did anybody else have a question for that? I had a question from the city. Is this considered a crime scene? Has an investigation been started or closed?
I do have the completed fire report is actually in the evidence that I gave, but it's about this thick, so I didn't make everybody a copy, but it is over there. I have spoken to this fire marshal several times. He said they could have started rebuilding or doing anything quite some time ago.
And they would know that because they had sent information to them, or?
I'm not sure what they sent.
And we don't have anybody
Yeah,
from the
I
fire
don't know.
department
All I
here.
know is he said that this has been sitting for a very extended period of time where it didn't have to be.
Okay.
I have a question. Have you had the property, after you had it secured, inspected by the building official?
It's not secured.
Not that I'm aware of.
Okay.
No one's contacted me.
So after, but you haven't contacted the city building official either?
I have not, I wasn't.
Has the building official posted this property as unsafe and uninhabitable? Is it currently posted by the city as such?
It was, I do believe, after the fire occurred, but there's no longer any postings anywhere.
So there's currently nothing posted by the building official declaring it an unsafe structure
Not
and
at this time.
uninhabitable?
No, ma'am.
And now, I also wanted to ask you, it says that you're proceeding under the International Property Maintenance Code, but you're not proceeding under the standard unsafe building and abatement code pursuant to
Because-
section 6-1.
Yes, I did not go under that. I wanted to just do the property maintenance to try and get this fixed instead of making an unsafe structure.
Okay.
So is the goal for the city, we always want to try to make everything safe. That's our first thing.
That's our goal.
Do you want them to board it up or tear it down?
I'm not a building official. It's whatever, our main goal is to get these people back in their home. That
Absolutely.
have been displaced. So our remedy needs to be finalization to get them back in the home and have the units made livable. Whatever it takes for them to be made livable and have the people back in is what we are seeking.
I'm with you 100% on that, but my main concern is we all know that even if we had unlimited money and started today, nothing's gonna get built right away. So immediately, I'm worried about a kid or somebody wandering into one of these buildings. So if they can show 100% the buildings are secured pending all of the red tape for rebuilding, does that satisfy your issue? If the building is secured, we can consider that safe.
If it is secured, we can consider that safe, but that's not still making it safe to be livable in. That is keeping it safe from outside people going in, but it's not bringing the homeowners back into their home. So it's still not up to code. We need it to
Okay.
be up to code.
Okay.
We just hate penalizing people that have already been slammed down. It's hard.
It's hard.
No permits have been applied for at this time.
How soon could you get a permit, get your application in for a permit for this?
We have the engineering. We were told once those were ready, we can sign with the new construction company, and they said they could apply for permits immediately.
Officer Stoner, could you tell us how long you think between the time they apply for a permit, do you think it would be, how much time should be given, in other words?
Once the permit is actually applied for, it usually is several weeks before the review is completed and it's actually issued for the work to begin.
Typically, once you apply for the building permit, this board's work is done. So once they apply for the building permit, the building department takes over doing the inspections and making sure everything is being done in accordance with the permit.
But for now, do they need a permit to nail up the plywood and make it?
No, they do not need a permit to secure it so it's safe from outside.
Okay.
Typically, though, once you have a structure that has suffered this type of an issue, the city will send in a building official and will send in an engineer to examine the structure, make a determination as to whether or not it's in danger of collapse, and then post the building accordingly.
It was posted at one
Right.
time. I actually saw it, but I can't testify to that.
Just so you know, from the city's perspective, it's a twofold situation.
Yes.
The short time period where we will ask for is for securing. Obviously, there's been some work that's been done, but you've seen the pictures. It's not as secured as it must be. Then we would ask the board to give a reasonable time period for them to get a permit and move forward with working with the city. So we're really looking for two things. The biggest concern, though, is securing.
Yes.
And if we can do that under a short time period, I think that's reasonable. The second part is allow them to get their permit and determine what they want to do. I mean, that's up to them ultimately. If they're going to knock it down, rebuild, that's not so much the city's issue as long as they move forward and do something. So that time period may be a longer time period to look at.
And I do have another question. I don't know whether or not the city was looking to abate this. It doesn't say anything about abatement in the materials.
We weren't looking to abate it as long as the association is moving forward. However, the concern, and one of the reasons why we're here, is it's been a year and we understand all the red tape and things that happen. That's understandable. But we have to see some action moving forward. Otherwise, we will be pushed in the situation to have to go ahead and take the nuisance abatement action,
Right.
which nobody wants to do that.
So,
Could I have a question?
Julie?
yes, please.
If I understand right, the fire occurred March 2022. The engineering company was contracted in December? And is the engineering completed and ready for permitting?
Yes, engineering is done.
And it was in December?
Yes, and
Okay.
that was only because the insurance adjuster changed
I
his
understand,
stance.
yeah.
It was requested in December,
It was
I believe.
requested in December. We got the plans last week.
So, just one question, my last question, I promise. So why hasn't anything been submitted yet?
What,
Well, request for permits, why haven't we reached out and gotten your builders? I know you said, have you just I think you got the engineering
Well, I can address
design
that, it's my
in
fault.
December.
And the reason it's my fault is because what was provided to me for the association to pursue securement of a contract to proceed forward with a contractor, if I gave it to you, you'd spit in my face. The contract that they secured in an effort to have something at this hearing, it was abominous. It was the wrong association name. It wasn't AIA. It was the wrong numbers. Everything about it reeked of taking your down payment and running away. So we just need an adequate amount of time. This is a very large project. We just need an adequate amount of time to secure an actual legitimate contractor to perform the work. Because if we were to try and secure somebody at the Home Depot to do it so we could say, we got it in a week just like you guys wanted, here we are, we'd be out of money next week.
We don't expect that.
No.
And I didn't think you did either.
No.
But that's my fault for not having the thing submitted already, because I told them, I can't let you sign a contract that looks like that. You'll be coming after me at the next hearing. So that's why it hasn't been submitted yet. I can tell you one thing, that in my communications with them in preparation for this, they don't want to be here again. And I don't think you want them here either. But the fact of the matter is that the next steps are, of course, securing a contractor for the purposes of resolving the long-term issue. And I'll let the association speak to this and confirm if I'm right or wrong. But as far as securement, the conversation I had regarding this in an attempt to resolve this hearing before even proceeding was that securement, if we show up at the hearing without securement, it's gonna be a bloodbath. So secure the darn place. It's a shock to me as much as it is to you that it's not secured to your liking. I would invite code, the city officials, whoever it is necessary to ensure securement of the premises for safety within the next 48 hours. We're gonna have that place secured, locked up tight to the best of our ability, and if it's not enough, let us know. We will do it. That's not something that we play around with, because we've dodged a huge bullet on liability that no one got hurt. A year later, for someone to crawl in there and get hurt it would be the end of the association. They'd just dissolve it.
It would.
Yep. So that's something we take very seriously and agree with. I'm sure Rachel agrees as well. So that's our side.
Are all these people here part of your witnesses, or are these other people
Some
residents?
of them are mine.
Are you, okay.
Yes,
I just want,
they would like to speak to when they.
We had,
okay, yeah.
we had 2 other witnesses, but I believe, correct me if I'm wrong, you feel comfortable having presented the association side?
Yes.
I think they've done a good job of that. Cindy, can you clarify which of these things we have cited them for? I think I'm hearing the board correctly. We want to get the place sealed up, then we can move to tearing down and rebuilding. Can you clarify which of these violations we want to satisfy immediately and which ones we can put off for the new permits, just so we get the right things in the records?
Well, the first one would be the IPMC 111-1-1, which would be the unsafe structure. It just needs to be properly
That is for
secured.
sure the number one thing. That,
Correct.
oh, the one with the last item listed,
Yeah,
okay? And the other ones refer more to the rebuilding process?
correct, to bring it back up to code and to make it fit for a human
Okay.
to live there again.
Does that help you for
So
crafting up?
We do this as a two-part?
Yes, I think so.
Two-part motions?
I think we're going to have
Okay.
2 separate
Okay.
findings. Do you feel like you've been heard, folks?
Nothing further from the association at this time.
I do have a question. Why isn't the insurance company paying for housing for the people that got displaced?
That's not really your issue.
Yeah?
A separate issue, though,
That's
not.
a separate issue.
Not for us, I'm
Tec-
afraid.
Technically, that's
remit.
not within the purview of the
Horrible.
board,
Right.
but I certainly understand the question.
It's, we feel your pain, I'm so sorry.
Can we start taking them? They would like to speak. Whoever would like to come up and speak first?
Thank you very much.
If you wish to be heard in front of the board, please go to the microphone and tell us your name and your address and your relationship to the property.
My name is Sarah Lynn Wilson.
I can't
Yeah,
hear
speak into
you.
the mic,
My
please.
name is Sarah Lynn Wilson, 722 Haven Place. My unit was one of the ones completely burned, losing everything. And a lot of what I'm hearing today is very frustrating because it's the same runaround we've been hearing for the last year. Blaming this, blaming that. You notice huge months of gaps in time of just like nothing because nothing gets done. It's a very lackadaisical, blame this, blame that. This company didn't work, we'll switch to this, we'll switch to that. Well, I spoke to the detective at the fire department after getting tired of 4 months of hearing we're waiting on a fire report, where he explained they've been done. I got the report, they've been done. They didn't check with the fire department. They just say, we're waiting on the police reports and things. We're waiting on the fire reports. They didn't even go seek it out. I had to tell them. And they're still using that excuse after I've told them. It's closed. It's a done deal. There's nothing to wait on for that. We're all still required to pay our association fees every month on top of all of this, which is $573 a month, on top of being forced into renting at record high prices. Now, the house that I've been renting for the last year, the owner wants to sell, so I have to move again, uproot my kids, find another overpriced place to stay, when I should be moving back into my home by now, if it was handled properly.
Yep.
So if you're not competent to do the job, don't do it. Don't sign up to do it. That's how I feel. It's the most frustrating experience of my entire life. And I've gone into the hole financially, like you can't even imagine. and you just get a runaround. I've begged for communication. I've begged for people to tell me the slightest update just to give me something to hold on to for hope. I get nothing, zero. In fact, now the stance is the board has nothing to do with it. It's all Associa. Talk to Associa. The Associa doesn't return our calls. The company they hired doesn't even return our calls. When she called Associa after being on hold for 3 hours, they didn't even know about the fire under her address. They've not communicated with us whatsoever to give us any updates, whether it be Associa, whether it be the board, whether it be anyone. No one tells us anything, and in fact, they back off and don't even want to speak to us, and they just shut it down and say, we don't know anything, we're not handling it anymore, it's all Associa. This is the first time hearing that now this company they signed on with 7 months ago isn't working out, and now we have to hire a new contractor company to start the process all over again. Those kinds of delays, they're inexcusable. No matter what, there's no way there's that many balls dropped that many times over and over, and there's no reason for the lack of communication from them. None. I deliver mail to my own past residents at the Palms, and I hear more information from just random residents there that come up while I'm delivering the mail to say, did you hear this? Did you hear this? Or whatever. No, I'm the last to hear. We should be the first to hear. I hear nothing ever. And what I heard today almost made me sick to listen to it's just all of what I've been hearing for the last year summed up, but even more of it. And the worst part was to listen to them talking about waiting on inspections from fire departments and police officers when that has been told to them 4 months after the fire, after I found that out, that that's not the case, and they're still using that excuse. It's all excuses, and they don't care because it wasn't them. It wasn't their homes. It wasn't their kids. It wasn't any of it. So it's just like, oh, well, I'm spending time working on this. I sent an email today, or I made a phone call today, and that's it. And if it's over your head and you can't do it, then you got to pass and do it, give it to someone else, or maybe they should have had their attorney handling it for much longer or something. I mean, to me, there is absolutely no excuse for the months of time to go by. We're talking about something submitted in December. The fire happened in March, and blame the insurance, blame this, blame that, and it's all just a blame game, and none of it makes sense. And you guys just got to hear what we've been hearing for the last year, and it's all a bunch of nonsense. There's people living in their cars from time to time that lost their homes. It's a catastrophe, and it shouldn't be. So that's all I have to say about it.
Yes, sir.
Could I ask you a question?
Mm-hmm.
Have you filed a claim with your insurance company yet?
Yes.
Okay.
From the very start, my insurance company was everything.
Perfect, okay.
But they didn't provide cost of living.
I understand,
so
but you have filed a claim.
Mm-hmm.
But she can't build her house without the other ones being torn down and rebuilt.
There's
She's
nothing
stuck.
put in there yet.
Correct. Did anybody else feel like they need to, she's expressed it pretty well. There you go, now you get your time. Please tell us your name and your address.
My name is Jackie Lewis. I work for the City of Clearwater government. And I've been pushed like I'm nobody. I've been with the City of Clearwater for 14 years. And they help me as well as they can. $100 here, $100 there, because I didn't have insurance. My unit was 716. I moved the 1st of March, and this happened on the 14th. My first house after 30 years of living in this country, my American dream. All my savings. And I was gonna go and get insurance, but I was waiting for the furniture to arrive. New furniture went on fire, from rooms to go. I still am paying for it. As like I said, I don't have insurance. I have a good job, but I don't have enough money to survive. even though I'm a single woman. Still not enough because I'm paying $2,000 a month for rent. So it's just too much. I stopped paying my maintenance bills because I have a storage. I'm paying for the storage, and it was paying for the storage where I have my appliances that I was able to save because they were on the first floor. So I'm not paying, like I said, maintenance, the $500, almost $600, because I'm paying $500 for the storage. And I don't even know if they're gonna fine me because I haven't paid since October. I tried to get in touch with anybody and nobody got in touch with me if I was gonna be fined or not because I didn't pay. But like I said, I'm in the position I cannot pay. It's like pay the storage or pay the maintenance. And I mean, I don't make peanuts. I mean, I make good money, but it's not enough for what is happening right now. So, like Sarah Lynn said, 4 of us are mostly single women that we were affected by this. And that's why we feel that they are pushing us around. And that's not fair.
It's not fair, we understand. So sorry for your loss, thank you.
Thank you. So, like I said, no insurance. I've been just waiting. And I know when the time comes, I'm gonna have to get like a loan to start the inside, you know, but I know once this starts, I'm gonna be able to save that money that I'm paying rent right now and, you know, and see all the stories. I just don't know. I don't see an end to it.
And I'm going to cut you off there. We're so
Thank
sorry. There's nothing we can do about your costs and your losses, but we're going to try to get them to move on this quickly.
Thank you so
That's the
much
best
for your
action we
time.
can take.
I appreciate
Thank you for coming.
Thank you.
Anybody else feel like they weren't heard? Thank you. Does the board have any other questions? Otherwise, I think we need to hear a motion or two.
You have to give them the opportunity to rebut either the city or the association. I do have a couple quick questions for Mr. Todd for the record. Yes? No. Does your association hold regular meetings?
It's my understanding that they hold meetings consistent with their governing documents, yes.
Okay. And do you know offhand when those are and where those are?
I do not. They are set by management, and it's not my responsibility to set them either. They
Okay.
handle it as set forth in the governing documents of the association as required by Florida Statute
Statute,
718.
right. And in accordance with Florida statute, do they receive the financial statements for your association? The residents and unit owners?
Well, the
The
manner of...
annual financial statements and
Correct,
budget?
yes. There's an annual budget that's adopted. It's delivered in the same manner every year as required by Florida statute. It's delivered to all the members and upon request and can be received, and it can also be reviewed after a written request within 10 business days.
And if this board were to impose any sort of fine on the association, who ultimately pays that?
The association, by virtue of the members who would more than likely be levied a special assessment to pay for it. The fact of the matter is that everything in an association flows downward, the original trickle-down economics. Unfortunately, what ends up happening with associations of limited means is that they can get put into a situation where they either are looking to a special assessment, which causes the association to go into receivership, and then once the receiver gets there, it's like having 2 attorneys. And you can imagine how expensive that gets. So I do believe that when they arrived at the volunteer means of subjecting yourself to this level of scrutiny as a non-paid director, they really came up with a way of keeping costs low while getting at least some recourse involved. And we're not defenseless to the plight of the owners. The situation that was presented here is obviously one that no one takes pleasure in. The fact of the matter is that the board is in a likewise position of only being able to perform what they can perform, and they are dedicated to getting it done, particularly in light of everything you've heard here today.
But the board has delegated the authority to the management company, which has dropped the ball.
Well, they have to delegate something. So the management, so what they did is they hired, and you heard testimony to this effect, they hired they're not an adjuster, but that's the easiest way I can describe it. The company that they hired to obtain bids, to basically run the contracting side of it, to get everything for the...
That they hired, you mean the management company?
Well, the association hired them, the board. The board hired, signed off on, got the agreement to have them do the work.
Not through the management company.
They handle a lot of this stuff themselves because they're concerned that there are so much things that have to be done that they take it on themselves to do it. If they see it going slowly, they sign the documents themselves. I know that, what's the name of the company, PMA? LHR. Not even close. LHR was signed directly by the president to secure the contracts and to do the work. So it's perhaps not the delegation that's the issue, but rather the follow-through by the vendors after they've been secured. As I mentioned, we've had multiple vendors that have been utilized, and for whatever reason, they're unsuccessful in getting to where they need to be. The engineering contract, or the engineering plans that you received today, is over the hill as far as the board is concerned in getting to the next step. Now they can get the contractors, now they can get the bids for all the work, now they can do everything they need to do. This was the hurdle. And they're very optimistic that everything hopefully rolls downhill from here, but I've eaten bigger words than that before.
It's just hard for us to hold somebody accountable when the people that are going to end up paying it are the ones that can afford to the least. So we've
Right.
got to keep this in mind.
Exactly.
Thank you.
Yeah.
Nothing further? Thank you.
I would propose that we do the last of the items first. Would anybody like to make a motion? I think we were done, I'm sorry. No questions, no? Okay. Let's look at the last of the items listed that they have been cited for first, and let's address that.
Right.
Madam Chair, if I may, may I say one more thing? The reason for the higher fine is because it may give them some incentive to move a little quicker now, and they are always welcome to come back and do a reduction hearing as well. I just want to make sure that.
I'm just not sure money's going to help anything in this
Well,
case.
I'm kind of, I see where she's coming from because they've had, at this
A year.
juncture,
A year.
Here,
Correct.
yeah.
And I don't know if it's through benign neglect, incompetence, bad luck, or a combination of all three, but the fact that they went 6 months and then changed, and then have gone 7 months, and now we're just now over the hill.
Frustrating.
I'm more on the, coming down on the side of go with the fines, and if that gets them over and they get the permit in, then it's out of our hands. And then if these residents come back and they want to say and ask for a fine reduction, because ultimately, to your point, it's the residents that are going to end up bearing the brunt. But if it gets done, if this is the stick that helps get it done, these fine people can come to us later and say, hey, we were the ones waving up saying, help us, and now we want the fine reduction.
And they need to know that you do not have to hire an attorney to get a fine reduction, because there's more ka-ching, 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 sorry.
We're used to it.
But you would not have to hire an attorney to come back and ask for that.
I do.
And the fine would be shared, not just with the people that have been burned out, but everybody in your complex is affected by a fine. So that is the stick to move this along.
I do want to explain something to the board really quick.
Thank you.
I think you guys are probably used to doing something in a certain way. right? As you have been kind of set up, and as you all know, this is my first time here with you today, so I haven't really had the benefit of seeing how you all kind of operate before today.
And this one was a little bit of a
And this-
loosey-goosey one, too.
It is, and it's a little bit of a difficult one too because of the circumstances involved. But here's what I want you to know is that legally you do have some options here. Whenever I have done code enforcement, I always utilize a 2-hearing process, right? At the first hearing, you make a determination of whether or not there is a violation. So you look at the evidence that's presented and you make a motion to say, yes, there is a violation, or no, there is not a violation, right? And then you have them come back to your next hearing for the second hearing case to actually then impose the fine. You determine whether or not there has been compliance with the initial order that you entered during the first hearing. It looks like from how your materials are structured, that you guys have always done the fine at the same hearing as the violation.
That's not
That's a
true.
recent change,
Oh, okay.
just
okay.
to speed the meetings up.
Oh, okay. But you do have that option as the board. If you want to separate that out, you can just find the violation today, give them a specific period of time to correct it, and then if they have not taken the action within the amount of time that you have set to have them correct it, then you impose the fine, and you can go up to that full figure, which is that $250 per day for a first-time violation. So as you kind of enter into your deliberations, I want to make sure that you know you have that option.
Understood. And also, Mr. Olson has said point blank, and I think the chair had said, a 2-tiered citation, because the safety issue is the first thing. So
Correct.
safety, and
Yes.
the number 48 hours has been thrown out there already, but, hey, safety is paramount here.
Right.
So we got to make sure this thing is secured, and the rest of it can follow through with that as well.
Once it's secured, they should have the building, typically what you would do is secure the structure, then call the building official to come and inspect
Agreed.
and make sure it meets that unsafe building abatement code, and then post it so that people do not enter unauthorized.
So, thank you.
Yes, sir.
Just a quick comment. I am a licensed community association manager and board member of our condominium and have been for 12, 13 years. It's unfortunate. The number one effort whenever you have a disaster is to secure the property and then start getting it prepared. The fact that they waited 9 months to even get an engineer on hand, and yes, I understand they ran into problems. You can't blame it on the insurance, or you can't blame it on the insurance company, you can't blame it on the property manager. There are other avenues. You can always go to the bank, take a loan or a line of credit, and get things moving quickly.
So, Madam Chair, let's get back
Let's-
down.
yeah.
I'll do the motion.
All right, would you like to make a motion, please?
But I want to know what I'm motioning. Are we just doing the
This will be
safe
for
structure at
unsafe.
this moment, not the other part?
Let's throw it out there and see what happens.
You
make a
want to do
motion.
just the safe structure?
Yes. That's your choice, if you'd like to make that
Well,
motion.
I'm
Then we'll
concerned
find
about-
out if that goes.
Yeah. Yes.
You can't have
I think you
side
can't have a side
conversations,
conversation, Mr.
unfortunately. This
Sorry
is,
about
this
that.
is a sunshine board, so everything you say has to be on the record, please.
You have something to say so.
One of the two of you would like to
don't
make a
have
motion.
I'm all set.
Okay.
Okay.
Sorry, I apologize.
It's okay. I move in the case 23-0800000019 to find the respondent, Palms of Tarpon Springs Condo Association, violation of the City of Tarpon Springs Code of Ordinances, Section IPMC 111.1.1, unsafe structure, for the property located at 600 Haven Place, Tarpon Springs, and to give the people at this site 1 week, not even 1 week, 1 week, to bring the property to a safe structure as certified by being inspected and labeled. It's properly labeled.
May
And
I
I'm
have
not
a
opposing a
date?
fine at this point, right?
No.
No fine?
Yep.
Do I hear a second?
I'll
What-
second that.
Okay.
All right,
How are we not, you're giving them a week, but what, you don't want to impose a fine?
Okay.
You,
Are
so-
we, are we gonna impose?
you can
it?
decide,
said
you
wait.
can
up to
vote
you
no,
all.
and then
Yeah.
you can propose a second. Your suggestion is that there be a fine if it's not done in a week. Would you like to amend your motion? Or do you want to leave it?
Do we go with the $250 a day? We'll go with the $250 a day.
So the motion
that
as it
meet
now
your-
stands is that they have 1 week to secure the premises
Or suffer the fine.
and have the city come out and post it, or the fine is $250 a day. And then we're
Period.
going to address the rest of these issues after that. I'm sorry, sir, we can't take it at this point. So,
I'm okay with that.
and that means the fine goes to everybody, not just the folks that were affected.
that's
So
the part,
the board needs to move on this if this is passed. Bobby, would you like to call roll, please?
No, you have a second.
Oh, do we hear a second? I'm so sorry.
Second it.
Seconded.
Ms. Eisner,
Yes.
Dr. Matei is absent? No.
Oh, we needed to make a note that Dr. Mateo had to leave at that point.
Okay,
So
then we'll
in our
list-
minutes, we will mark down that there will
That-
only
that-
be this board voting at this point.
Okay, then I will go to Mr. Ogle for his vote. He'll take in Dr. Matea's position. So, Mr. Ogle,
Yes.
thank you, sir. Mr. Robinson?
Rolliston?
Ralston.
Yes.
Austin? Oh, okay. I'm sorry, apologize. Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes. Will you summarize that for them, and then we'll get to the rest of it?
Absolutely. So the motion was for you to bring the property into compliance by having it secured and posted by the building official within 1 week of today's hearing. And if you are not in compliance, then the fine will begin to run at $250 per day until this board determines that you are in compliance.
And you will be sent this information after the meeting. Now we need to address the other complaints that were made. Questions, suggestions, proposals?
Well, I understand it's going to take, understandably, some time to get permits and whatnot, but at the same time, we're going on a year here, and we've got people without a home, so.
That's right.
And their testimony was that they're ready to roll for these
No.
permits.
So, I mean, I'm open to suggestions. What do you, I mean, 45 days, 30 days, what do you? what-
30 at the
30
most.
days?
I want to see
30.
these permits applied
Nothing
for.
less than 30. They wouldn't, nothing less than 30. They're going to take, setting them up for failure if it's less than 30.
Could I make a suggestion?
Yes, sir.
It's my understanding that the engineering data is ready. I would like to propose or add to your motion that within this next 7 days, that the application for permit needs to be submitted to the city. That gets it started. I hate to put fines against the association because it's the people that are going to pay it.
That's-
It's not the association, they're not wealthy.
This is the hard part for us to
This is the hard part.
understand this. We need to give
However-
an impetus, but we don't want you having to suffer anymore.
But they do,
I'm sorry.
but you need to react. So
Mr.
1 week, submit the,
Ralston, would you like to amend your motion to break that down into,
You think 7 days, they can get an application in the 7 days?
I know that, I just did an application this morning on the city. You can go online, put the application in. That gets it started. Is that correct?
Yeah, well, the city is not, I would make a recommendation by the city that you do a separate motion. We don't want the two issues to be under the same motion, because if we have to implement a fine, we want it just to be clean. Your second motion, the city is certainly willing to give it some additional time than 7 days. Because you know the process, different things happen, different requests. We expect that they will act pretty quickly as being presented today, so we're fine with a little additional time if the board wants to consider that.
3 weeks?
30 days.
I need a clean motion.
Oh, yeah.
Let's withdraw the two motions that have been made
No.
and
No, we
I don't
only
think
had
a
the one
motion was
motion.
ever
One
made. I don't
motion's
think there
okay.
was-
No motion was ever
Yeah,
made.
that's
You have
okay.
the first one that addresses the
Unsafe
unsafe
structure.
structure. And what you're looking for here is the property responsibility, because here, looking in the materials, there's essentially 3 charges.
Yes.
Failure to maintain responsibility, structures unfit for human occupancy, and then the unsafe structure. So you dealt with the last one, and then you have the property responsibility and structure unfit for human occupancy to deal with.
correct.
And the city would recommend that you have a period of time for the permit.
Right.
And a second period of time for completion. The second period of time, you can either do several different ways. You could bring it back to the board to see what the status is. You can give them a long enough period of time for completion, something that's reasonable, but we'd like to see both. Because if they don't apply for the permit within a reasonable period of time, then we have to make a decision on nuisance abatement.
Yeah.
Thank you.
So Mr. Rolliston's
So then,
motion is still hanging out here without a second and needs clarification
What?
for me.
No.
I don't think I really made a motion. I was just asking for what people felt in the time.
Okay.
And now hearing from the attorney, so I'll make a motion that in case 23-800-0019, to find the respondent Palms of Tarpon Springs Condo Association in violation of, so which one is the,
The
For the-
the 2 IPMC codes.
for IPMC 301.2, that we want to see a permit submitted to the city within, what's today? 3 weeks, 9th. By April 10th. So that gives them a month to get the permit submitted, or suffer the fine of $250 per day beginning on April 10th thereafter.
Do you have to include 111.1.3 in that as well?
If you want, you
included
can do both.
301.2, but
Do both? Yeah, I apologize. Yeah, we'll do both IPMC codes, 301.2 and 111.13.
yeah.
Could you just add, submit an application for permit instead of submitting a permit? Application for permit.
Submit an application of permit to the city.
Do I hear a second?
I'll second it.
Roll call, please, Bobby. Did you attach the 250 to that?
Yes.
Okay.
Mr. Ogle?
Yes.
Ms. Eisner?
Yes.
Mr. Rollinson?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
And Ms. Wade?
Yes. Would you like to try to summarize what we just did?
Yes, for the condo association, you have been found in violation of the responsibility and unsafe structure and unfit for human occupancy provisions of the International Property Maintenance Code. You have until April 10th to submit permits to the city, whether those are for demolition or for rehabilitation, whatever is determined to be appropriate by your engineers and the city building official. If you do not submit those by April 10th, then the fine will accrue at $250 a day, and this item will be reheard at the April 13th Code Enforcement Board meeting for compliance with those 2 items.
Thank you all for coming. We really feel horrible for you, and I see how your hands are tied and how frustrating it is, but we got to get on this. Thank you so much for coming. everybody okay to go on for just a little bit? Nobody needs a break? Okay, thank you. Case number 3. Thank you, Officer Boone. Case number 22-8000371 Gulf Marine Ways. It's a parcel. Is there anyone here for that case? Thank you. The city will present its case.
On November 21st, 2022, I inspected the property located at parcel number 12-27-15-53352-002-0060 due to a citizen complaint. This is a vacant corner lot that has not been approved for any type of business, storage, or other uses. There had been a large wooden structure built without permits that was for a new golf cart business. A portable kiosk was also added to the property for the business. However, at this inspection, there were no golf carts on the property and the business was not actively open and running yet. On November 21st, 2022, the property owner, Louis Masald, met with code enforcement, planning, and building departments to discuss the violations. He was advised that no permits were obtained for the structure on the property, the kiosk is not allowable, and that his parcel has no available uses for a business, has no business tax receipt, and would require a conditional use variance. The property owner advised that he would meet with the tenant and owner of the business who rents the property from him, and advised that the business had to be moved. He stated he will also obtain permits for the structure and remove the kiosk. The property owner was given a verbal notice of the violations, and he agreed with a compliance date of December 14th, 2022. A reinspection was completed on December 14th, 2022, and found that no efforts had been taken to bring the property into compliance. And the golf cart business was now actively running, had multiple golf carts under the structure, and the kiosk remained with advertising of the business. The property was posted with a notice of violation with a compliance date of January 3rd, 2023. A copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. A reinspection was completed on December 30th, January 3rd, 12th, February 13th, and 21st of 2023, and found that no efforts had been taken to bring the property into compliance. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by removing all the golf carts, the kiosk, the structure from the property, and ceasing all business activity on the property. If a business is wanted, a conditional use variance permit will be required for review, and if approved, a business tax receipt will be required for any business occupying the property. If the structure is to be remained with use of a licensed contractor, proper permits are to be applied for, approved, and issued for all work that has been completed. A hearing notice was posted on the property on February 22nd, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until March 29th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $75 per day, beginning on March 30th, 2023, until the property is brought into compliance. Exhibit 2 is going to be the property without the golf carts. This is the structure that he built, and the blue circular thing is the kiosk that he brought in. Further inspection on December 14th, 2022 shows that the business is operating. All the golf carts are under the structure. On December 30th, 2022, the golf carts were still there. Exhibit 3 is going to be the notice of violation, certified mail receipt, and signature return card, and the affidavit of posting. He also got another notice of violation. When we first did the violation on this property, it was on the wrong parcel number in our GIS computer system, so I had to reissue another notice of violation under the correct parcel number. So that gave him another extension of 30 days to come into compliance. That also has the certified mail receipt, the notice of hearing, the certified mail receipt, and the affidavit of posting. And then Exhibit 4 is going to be the property appraiser, tax collector, and Sunbiz. There are 2 Sunbiz in here. The one that is actually on the property appraiser is an inactive company. There is one that is active, but it's a different, it says LLC instead of an INC, so I included that just in case. As of today, the property owner called. It's the first time I've had any contact with him since our meeting back in November. He said that he is removing the structure We'll get rid of the kiosk, and he was not able to make it today.
Okay. Where is this?
It's right off of Dodecanese,
Where the
right by
Niagara.
the roundabout. If you take a right on the little roundabout down there, it's right on the corner.
Thank you. Oh, I see the map now. Anybody have any question for her?
What does compliance look like?
Either he needs to apply for a permit for the structure that he built, and have the permit applied, approved, and issued. The kiosk needs to be removed and the business needs to cease. Or he can just completely remove the kiosk, the business, and the structure without a permit. He'll be fine.
Does he have a license to operate this business?
No.
What do the little signs say on the posts in the picture?
No parking, no smoking?
No parking.
Underneath it?
It's laughable.
It does.
It would, yeah, there are no parking signs, so cars don't park there up against it, because that is actually a little roadway right there.
So he's told you on 2 separate occasions now, he's gonna just take everything down.
Yes, sir.
Motion?
I move in case number 22-8000-371 to find the respondent, Gulf Marine Ways Incorporated, in violation of the City of Tarpon Springs Code of Ordinances, Section 11-36-1, and Florida Building Code, Section 105.1, for the property located at parcel 12.27-15-53352-002-0060, and to assess a fine of $75 per day beginning March 30th, 2023, until compliance is achieved, and to order the respondent to contact Code Enforcement Division to arrange for reinspection of the property and to verify compliance with the board's order.
Second.
Roll call, please.
Mr. Ogle?
Yes.
Excuse me, Mrs. Eisner?
Yes.
Mr. Rollinston?
Yes.
Mrs. Tellier?
Yes.
Mr. Weeks?
Yes.
Mr. Fafidio?
Aye.
Ms. Wade?
Yes. Item 4. 23, case number 23-80000. 009, KPM Tarpon LLC, 38954 US Highway 19 in Tarpon. Is anyone here for that case? City will begin.
This is not a homesteaded property. On January 18th, 2023, I inspected the property located at 38954 US Highway 19 North due to a citizen complaint. This is a vacant parcel with a partial building shell structure on it from a previous business. The entire property was overgrown with grass, weeds, and other vegetation in excess of 12 inches in height and was scattered with junk, trash, debris, broken glass, furniture, and personal items. The walls of the structure were also painted with large, vibrant paint graffiti. The property was posted with a notice of violation with a compliance date of February 1st, 2023, a copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. A reinspection was completed on February 1st, 2023, and found that no efforts had been taken to bring the property into compliance. On February 2nd, 2023, the property owner was present at a TRC meeting regarding the property. At this hearing, he was advised that there was still an open code enforcement case regarding the violations and that no efforts had been taken to bring the property into compliance. The property owner advised that it would be cleaned up soon and taken care of. Several further re-inspections were also completed on February 6th, 8th, and 15th of 2023. The front of the property had been mowed, however, the rest of the property was still overgrown. The graffiti was painted over in a gray color, and all of the junk, trash, and debris, furniture, and other items still remained. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by properly removing all junk, trash, debris, broken glass, personal items, furniture, etc. from the property, mowing and maintaining the entire property of all grass, weeds, and vegetation below 12 inches in height at all times, removing all graffiti from the shell structure, and regularly monitoring the property to keep it from becoming a nuisance to the city. A hearing notice was posted on the property on February 22nd, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until March 24th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $150 per day beginning on March 25th, 2023 until the property is brought into compliance. It also should be noted that there are multiple prior cases on this property. It just wasn't made as a repeat violator.
Why was it not a repeat violator?
That was my error. I didn't catch it when I started the case.
And we can't correct that at this point?
No, I did not notice them as a repeat violator, so
Okay.
we had to give them the time.
All right.
Exhibit 2 is going to be a multitude of photographs that have been taken on the property. It's become pretty much of a dumping ground. Transients are using it as well. There's broken glass all over the ground. Exhibit 3 is going to be the notice of violation, along with the certified mail receipt and the signature card, along with the affidavit of posting, the notice of hearing, certified mail receipt, and affidavit of posting. Exhibit 4 is going to be the property appraiser, tax collector, and Sunbiz. I was out there again just prior to this hearing. There's new graffiti that has been put up. The furniture is still out there. The broken glass is still on the ground, still has not been mowed.
Yeah, my concern is this thing has been a blister, and obviously you weren't aware that it's a repeat violator, but this thing has been a blister for years now. And it is an attractive nuisance, as, you know, you attested based on graffiti, bottles, and whatever else vermin is running around there, who knows? So, I'd like to make a motion.
May I just say one more thing? The property owner is going through the proper steps to build this up. It's taking an extra long time for some reason. But again, he is aware that he needs to keep the property maintained until that process goes through.
We heard that 2 years ago.
Okay. This is my first time with this property, so I'm not familiar with that.
So, I move in case number 23 dash, am I jumping the gun here, Chair?
No, go ahead.
Okay. I move in case number 23-8000009 to find the respondent, KMP Tarpon LLC, in violation of the City of Tarpon Springs Code of Ordinances, Sections 8-40, 8-52, 9-1, and IPMC 302.9 for the property located at 38954 U.S. Highway 19 North, Tarpon Springs, Florida, 34689, and to assess a fine of $250 per day beginning on March 25th, 2023, until compliance is achieved, and to order the respondent to contact the Code Enforcement Division to arrange for a reinspection of the property to verify compliance with the board's order.
I'll second that.
Thank you. Roll call, please, Bobby.
Mr. Ogle?
Yes.
Mrs. Eisner?
Yes.
Mr. Rollinston?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Pavidio?
Aye.
Ms. Wade?
Yes. Shall we, is there anybody here for case 5? I'm going to switch up and put case 6 here, because there's somebody here for that case.
I'm sorry?
Is somebody here for, tell me what case you're here for. We're going to move it around.
Number 6.
6, let's move. There's nobody here for 5. Let's move you up so you can get out of here. You're 5? That's what I thought. Let's move to case number 6 next.
Throw the book at her.
So we're just switching order.
It is, typically when you change the order of the agenda, it should be done by a motion of the board, so we can just get a motion on that on the record,
Make a
please.
motion to change it.
Okay, thank you.
I'll second that.
We could do a voice vote. Everybody in favor?
Aye.
Thank you. We're never that formal on that item.
Okay.
Let's do number 6 so she can get it going.
This is not a homesteaded property. On January 31st, 2023, I inspected the property located at 109 Hibiscus Street due to a citizen complaint. This is a commercial business that is on the corner with an alleyway. At the rear of the property is a large oak tree that appeared dead and diseased as well as hazardous. The tree hung directly over the business that the public frequents, an alleyway for pedestrians and vehicle traffic, as well as another business at the rear. Per the complainant, the tree has already dropped large branches that broke the neighbor's business fence. The property was posted with a notice of violation with a compliance date of February 21st, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. On February 6, 2023, the property owner spoke with myself along with Sergeant Miller regarding the violation of the tree. She stated that it would not be aesthetically pleasing to remove the entire tree, that she did not agree to remove the entire tree, and that she recently had it pruned and it's not dead. She was advised that the tree is a hazard, to which she stated it was only a hazard to her business, not anybody else. She was advised that the public frequents the business, which would also put them in danger. She was referred to the city arborist for further information and clarification. On February 7th, 2023, City Arborist Shannon Brewer met with the property owner to discuss the violation. She advised the property owner that the tree was hazardous and is in a spiral of decline and would require a permit for removal. The property owner advised that she only wanted to remove a part of the tree due to possible financial issues. On February 7th, 2023, City Arborist Shannon Brewer sent an email to myself advising of the meeting between her and the property owner and that she recommends complete removal of the tree. I responded that I was in agreement and that the tree needed to be removed completely as it posed a hazard not only to the business but also pedestrians and vehicles. The property owner was copied on this email as well, however did not respond. A reinspection was completed on February 16th, 2023 by City Arborist Shannon Brewer and found that no efforts had been taken to bring the property into compliance and no permits had been applied for and the tree remained and no further contact had been made from the property owner. Due to non-compliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by utilizing a licensed tree company with proper permits to remove the dead tree in its entirety. Permits are to be applied for, approved, issued, and finalized. A hearing notice was posted on the property on February 25th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until March 16th, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $75 per day beginning on March 17th, 2023 until the property is brought into compliance. Exhibit 2 is going to be a picture of the tree at the rear of the property. There's several pictures of such. And then a picture on February 16th that shows that the tree remains.
Sherry, you can see everything if you wanted to. What we're looking at is up on the podium. Under number 6.
Exhibit 3 is the notice of violation, along with the certified mail receipt and the signature card and the affidavit of posting, the notice of hearing, the certified mail receipt, and the affidavit of posting. Exhibit number 4 is going to be the property appraiser tax collector. And Exhibit 5 is going to be the email that was submitted between myself, the respondent, and the city arborist saying that the tree is very hazardous and needs to come down immediately. As of this morning, I did hear from the respondent. She advised that the tree has been removed. However, it's going to need to be inspected and finalized by the city arborist. She is out of town at a conference right now and will not be back until next week.
Do you have just a question for her at this stage, and then you'll get to present your case after that?
This is certainly not as awful as some of the things that came through here today. I wanted to leave a couple of pictures with you that I have, and I wanted to put them in.
I'm going to stop you. Do you have a question?
I do not have a question.
Okay.
I do not.
We will let you present your case, and then.
Thank you.
Thank you.
And it isn't really a case. It's just that I may end up in trouble again. So because I also wanted the board to know, and people who are involved with trees, it's not easy to get somebody to come out in 3 weeks even and take down massive trees. And I had after 8 different people, 3 of them arborists, the prices ranged anywhere from $5,800 to $3,000. And the 3,000 guy was, what I found out, wasn't even licensed and permit. He couldn't even do it right. But he didn't say that in the beginning. So, and it was frustrating because I know it sounds like I was just terrible and I wasn't complying, but this is two big, huge trees that grew together. And they're on the back of my property, and they can't, and the tree in the back was dying. And I'd already had somebody come out and start taking it apart. And then the rest of that tree in the back that was way up in the air about, I don't know, 50 feet, I discovered I needed a bucket. I mean, I've never taken out a big tree before. So I was trying to get somebody to do that, and I was getting horrible prices even just for that section. So then I get this, and actually before that even, I spoke to the people who, it's over the RealNet property, which is just one big vacant piece of property. And a piece of the limb off of the bad tree in the back fell onto their property, and I was able to clean it up. We went through it. I told them, I promise I'm going to take it out, and I started working on it. Then I got a notice that somebody had turned me into code enforcement, and I thought, well, gosh, I just talked to these people. So then I started trying, and I did take a while, but it isn't easy when you're working with, you have to get on somebody's schedule. But in the middle of that, I really was begging and pleading to let me maintain the tree in the front, which was beautiful, in my opinion, but I'm not an arborist. But I did end up hiring an arborist after talking to different ones. I've got his bid here, but also that I paid him. I paid somebody to do it. In that process, I did ask him, okay, I know I have to do it. I was there. I wasn't happy about it, but I was there. I said, is there any way you could leave a little bit of, and it's huge, a little bit of the trunk in the front so that I could do something strange and cutesy with it. I wanted to put ferns. I wanted to put staghorns. I wanted to do something other than look at this ugly lot behind me that was awful. So I know, because he said, well, you're not taking it totally to the ground. I said, well, then I'm just going to be looking at nothing, and it'll be really ugly, and I have this really cute store. So he said, well, I can tell you, I'll take you down to the level of what I know is safe. So in case I come before you again, I have a picture that I had him take my huge, beautiful stump down to about 3 feet. And then I put air plants on it. And he told me it was safe, there wasn't a problem. And I know Shannon hasn't gotten to look at it yet. I told him that he may be back, but I'm just saying that it was awful to take down, and you'll see, I mean, this tree that I had there was gorgeous, but she said it was going to die in time. So, but not in my lifetime, probably. I just wanted to save it. So I've saved a piece of the trunk, and if I come back before you, then you're gonna know why. But I did do it, and I did use an arborist, and I'm gonna leave this with you just in case.
Thank you.
It is done.
You give it to Smith.
Is this more evidence that she's wishing to have put in the record?
Yes.
Because I was told I needed to put it in the record.
Yes.
That it's done.
We'll be done in a minute. Thank you. Jen, Cindy said the tree's down, it's just a stump, she's complied.
Right. While Attorney Salzman is reviewing what she provided, now might be a good time if anybody has
Take a
questions.
5-minute break?
Or take a 5-minute break. It's up to you all.
Let's, the board is adjourned for a brief recess, and we'll be back in just a few, 6 minutes. Your 6 minutes are up.
Because you can keep standing up, doesn't mean that.
Code Board meeting is resumed. Thank you. You had completed your testimony. Does city have anything else to say, and we'll be ready to vote?
Yes, I do. I did look at those pictures. Though she is not in compliance, the trees have got to come all the way down to the ground. She cannot leave stumps. It's part of a code. I've told her that several times. Shannon told her that as well. So it's not compliance until it's to the ground.
I understand, but if the code says, we gotta follow what the code says. You can. That would be so sad. I know. Anybody like to make a motion?
The attorney here?
Pardon?
Do we need our board attorney, or are we good?
Not for, I don't
No?
think so.
Okay.
I'm ready.
Oh, there you are. I just didn't know if you were gonna come back in and be like,
No,
what
we're
have you done?
moving on without you, girl. Both people, and this they already have a copy of, I think.
Okay.
Ready?
I'm going to accept her additional evidence into the record officially, and Bobby's going to mark it received. And then this is the copies of that other one that she already has. They're all the same.
Okay.
Do you want to go to the mic so it can get recorded?
Then they're not in evidence, they're just extras.
Yeah.
Thank you.
So what is that stump not safe for? What is the not safe about it? It's about right here. It's at the back of a property. There's an ugly fence behind it. And according to my arborist, he said that is part of the code, but your safety is not your safety. You don't have a safety problem here because there's nothing there. There's no branches, and it's very healthy.
It's still part of the code. I cannot bypass the code. The arborist said that they need to come to the ground.
Well, I know that's the standard, but in
The code also states that you cannot have a tree stump like that. If a tree is removed, it has to go to the ground.
But why?
I didn't write
A
the code.
lot of ordinances that we change all the time. I mean, why are we doing that?
You understand, it's not up for her to
I know,
decide. She
I
just
know.
enforces it, whether you're in compliance or not.
So is it?
So I'm going to call you out of order,
no, that's
and we're
okay.
going to go ahead and vote. Thank you.
I move in case number 23-800000016 to find the respondent Sherry Went in violation of City of Tarpon Springs Codes of Ordinance, Section 133.02, for the property located at 109 Hibiscus Street, Tarpon Springs, and to assess a fine of $75 per day beginning March 17th until compliance is achieved, and to order the respondent to contact the Code Enforcement Division to arrange for reinspection of the property to verify compliance. Will she be back by the 17th?
She will, but until it's completely removed, it's a moot point.
Okay.
When is Shannon back?
She'll be back Monday.
A second.
Roll call, please.
Mr. Ogle?
Yes?
Mrs. Eisner?
No, I think more time should be given to get the
Miss-
stump removed.
I didn't hear you.
I think more time should be given to get the stump removed.
Mr. Rollinston?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
No.
Video?
Aye.
Ms. Wade?
Yes. Motion carried. Will you summarize for her, please?
Yes, Ms. Went, you have until March 17th to remove this, to have the stump removed and have it inspected by the city's arborist. And if that is not accomplished, then a fine will begin to accrue at $75 per day.
They will send you the official order. Ma'am, what case are you here for?
Number 7.
Madam-
And sir?
Number 8.
7 and 8.
Yep.
And you said I have to ask for changing it around now?
Technically, you're still going in order.
Yeah, now we're on
Yeah,
7, so.
We're on 7, so.
Okay, so we'll do 7, case 7 next. And we'll come back to
5 after.
5 after everybody's gone. Ma'am, if you'd like to come to the microphone, the city will present their case, and you're going to tell us who you are.
Thank you. My name is Molly McGuire. I'm an attorney representing Palm Spring Estates.
You can follow along in the.
Martha
Oh.
McGuire?
Molly.
Molly McGuire. A great name.
Great name.
7. I should have everything. Yeah, thank you.
Charged by the hour, she doesn't know how long she waits.
This is not a homesteaded property. On December 7th, 2022, I inspected the property located at 40110 US Highway 19 North, Lot 44, due to a citizen complaint. Upon arrival to the property, there was a wooden deck partially built, junk trash and debris on the property, and a jet ski and trailer that were inoperable. The property was posted with a notice of violation with a compliance date of December 22nd, 2022, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. A reinspection was completed on December 22nd, 2022, and found that no efforts had been taken to bring the property into compliance. Several further inspections were also completed on December 28th, January 19th, February 1st, February 9th, and February 17th, and found the same, and no contact had been made from the property owners. Due to noncompliance, the property was referred to the Code Enforcement Board. Compliance can only be achieved by utilizing a licensed contractor to apply for proper permits for the deck that was built and having the permit in the issued status, and having all vehicles on the property, included trailers and recreational vehicles, be operable with valid tag and registration. A hearing notice was posted on the property on February 22nd, 2022, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends giving the respondent until March 23rd, 2023 to achieve compliance. If compliance is not achieved, staff recommends the Code Enforcement Board impose a fine of $100 per day beginning on March 24th, 2023 until the property is brought into compliance. Exhibit 2 is going to be a picture of the deck that was built, as well as the inoperable jet ski. There's further pictures that show that the deck was not removed. The jet ski remained, and more junk trash and debris continued to pile up. Exhibit 3 is going to be the notice of violation, the certified mail receipt, as well as the signature card and the affidavit of posting, the notice of hearing, along with the certified mail receipt and affidavit of posting. Exhibit 4 is going to be the property appraiser, tax collector, and the Sunbiz. I was out there again just prior to the hearing. All of this stuff and inoperable vehicles has now spilled over into the street, and I still have not heard from anybody that runs the property.
Do you have questions for her?
I do, just a few. Prior to, well, first, let me start with this piece of property that Palm Spring Estates own. Is it being operated as a mobile home park?
Yes.
And the violations up until today, apparently, where the cars are leaking out into the street, prior to that, were they fully contained within Lot 44 of that?
They were
park?
up to the right-of-way.
Okay, but they were still within the confines of that lot? Okay, thank you. I have no further questions.
Unlicensed and untagged.
Yes. Those were all of my questions.
Thank you. Would you like to make your case, please?
Sure, I don't have any further evidence other than that. Our main argument here is a point of law and not fact. We have not, up until today, if it's crossing over into the roadway, this is the first knowledge I have of that, or I think anything else. But prior to today, all of the violations were caused by a tenant on the mobile home park property. The argument is that the responsible party for that violation is, of course, the mobile home owner who owns all those vehicles. And our position is that obviously, this board's empowered to issue those notice of violations. That power is limited to violators, the responsible party for that violation. And prior to the after the 1980s, landowners were automatically responsible for these violations, regardless of whether or not it was attributable to a tenant. But in 2011, the legislature enacted chapter 723 and section 723022 and 023 essentially bifurcate responsibilities for code violations between the mobile home park owner and the mobile home owner themselves. 723023 states that a mobile home owner shall at all times comply with building, housing, and health codes, including compliance with all building permits and construction requirements for construction on the mobile home and lot. The homeowner shall also keep the mobile home and lot that they occupy clean, neat, and sanitary, and maintain it in compliance with all local codes. So, under these statutes, the mobile home owner is responsible for all of these violations, and section 72304 states that notwithstanding any other local law, ordinance, or code, the local government must charge the responsible party, and no lien, penalty, fine, or other administrative or civil proceeding may be brought against a mobile home park owner or park property for any duty or responsibility of the mobile home owner. So this has been interpreted by at least one court to mean that the homeowner is responsible for any code violation that occurs above ground level, and then the park property is responsible for everything that's beneath ground level. Obviously here, the homeowner is the one that initiated the unlicensed and unpermitted construction, and then of course prior to today, all the vehicles were located within the bounds of that person's lot. And then furthermore, these violations were actually reported by us, a member of the property management company. So if park owners are held to be responsible for the actions of the homeowner, then the park owners are going to be discouraged from reporting these code violations that are being committed by their tenants, which presumably Chapter 723 was enacted to prevent. And it's also poor public policy because in reporting the homeowners' violations, the park is working together with the local government to make sure that it's properly maintained within the goals of the local government, maintaining health and safety, the welfare of the community, allowing park owners to report their violations of their tenants without having to worry about having to go through something like this will lead to a better quality of life, increased property values, and frankly, an increase in the tax base for the local government. So that is our position. We are asking that this board find that the property, the park owner, cannot be responsible for these violations.
Do you have questions for her?
Yes, just a couple. So until today, you were unaware that any of this was in the common area or the right-of-way?
Right, I think up until today it was not.
Okay. And that area that we're talking about is solely owned by one of the mobile home park owners?
The entire property is owned by the mobile home park. The lot itself is leased by the tenant. The mobile home itself is owned by the tenant.
Okay, so for the clarification for the board, the property that is in violation, where these things are being stored, is not owned by the mobile home park?
I actually have definitions for this. Mobile home lot is described by a park owner pursuant to the requirements of the statute as a lot intended for the placement of a mobile home. So that's the lot. A mobile home owner, homeowner, or homeowner means a person who owns a mobile home and rents or leases a lot within a mobile home park for use. A mobile home park means the use of a land in which lots or spaces are offered for rent or lease or the placement of mobile homes. And then the mobile home park owner or park owner means an owner or operator of the mobile home park. So the tenant does own the mobile home that
All I'm trying to get at, I'm aware of the statutes. I'm trying to get at who owns the piece of property that's in violation?
Obviously, the mobile park owns it.
Okay.
Okay.
Anybody have any questions for her otherwise? Would you like to summarize?
I think he just did a good job.
Would you like to, we heard what you had to say. Do you have sentence summary?
I think you guys got it probably.
Would you like to make a motion?
Yeah, okay. I move in case number 22-800, get all these numbers here. 00408, to find the respondent, Palm Springs Estates LLC, in violation of City Tarpon Springs Code of Ordinances, Section 6-1 and 40.00, and Florida Building Code, Section 101.5, for the property located at 40110 U.S. Highway 19 North, Lot 44, Tarpon Springs, Florida 34689, and to assess a fine of $100 per day beginning on March 24th, 2023, until compliance is achieved, and to order the respondent to contact the Code Enforcement Division to arrange for reinspection of the property to verify compliance with the board's order.
Do I hear a second?
Second.
Roll call, please.
Mr. Ogle?
Yes.
Ms. Eisner?
Yes.
Mr. Rollinston?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes. Summarize quickly for
Yes,
us.
you have until March 24th to have the vehicles licensed or removed from the property and request a reinspection by the city.
Okay, thank you. Just to clarify, there were two violations, the unpermitted construction and the vehicles.
All of it.
Okay,
They were included in the motion for section 6-1 and 40. That's both violations, so yes.
okay,
So the deck will then require a permit in addition to the vehicles being removed or licensed.
okay.
Thank you.
Thank you.
Yours is number 8, sir? Thank you. We'll do number 8 next. Case number 2-8-00000384, Thomas Nath, 711 Pent Street in Tarpon. Are you Mr. Nath?
Yes, I am.
And is that your address?
Yes, it is.
Thank you. City.
This is just an affidavit of noncompliance and compliance. Mr. Nath was supposed to be in compliance on February 15th, 2023. When I did my inspection on the 15th, he was not. However, when I went back the following day on the 16th, he was. I believe he might have been confused, honestly, with the date of inspection and compliance. I think he thought I was coming out on the 16th because the date was the 15th. So, but he is in compliance now.
So he is here to have the $75 removed?
No, he would be owing for 1 day out of compliance if that's what you choose to do.
Can I make a motion? Okay, in case number 22-800000384, I find the respondents in compliance and of correcting the violation and expect the affidavit of compliance with no fine.
I'm sorry. Did you say no fine?
In compliance with no fine.
In compliance with no fine. Okay, sorry.
Do I hear a second?
I second.
No fine.
Roll call, please.
Mr. Ogle?
Yes.
Ms. Eisner?
Yes.
Mr. Rollinson?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes. Do you want to?
Yes, your property has been found in compliance and no fine has been levied.
Okay.
There's nothing further for you to do.
Thank you.
Thank you for coming down.
Thank you for
I
coming
just
in.
want to say, I feel so bad for those people. It's just, who are, could be homeless, but, yeah, I just thank you all for considering the financial leniency. I appreciate it.
Thank you.
Have a good day.
We'll back up. We had one more item.
Number 5.
Case number 5. It is a repeat violator case. The name is Stanley Kavoris and Dimitrios Kavoris. Case number 23-8 00000032. It's a parcel, and she's going to bring us up to speed on that.
This is not a homesteaded property. On January 16th, 2023, I inspected the property located at parcel number 1227-15-73-67-40000070 due to a citizen complaint. This is a vacant parcel in a residential neighborhood that is severely overgrown with grass, weeds, and other vegetation. There were also multiple tree branches and tree debris on the ground as well. The property was posted with a notice of repeat violation, which advised to comply immediately, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The property owners are repeat violators due to case number 19-800-00263, which found them in repeat violation at that time of the City of Tarpon Springs Code of Ordinances, Sections 8-40 and 8-52, on May 9th, 2019, and ordered a daily fine of $50. It should also be noted that there are multiple prior cases for the same violations as well. Due to this being a repeat violation, the property was referred to the Code Enforcement Board. Compliance can only be achieved by mowing and maintaining all grass, weeds, and other vegetation below 12 inches in height at all times, and properly removing the tree debris from the property. A hearing notice was posted on the property on February 16th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. The division recommends the Code Enforcement Board impose a fine as a repeat violator of $100 per day, beginning on February 16th, 2023, until the property is brought into compliance, and to accept the affidavit of prosecution and investigation costs for the respondents to pay $119.39. Exhibit 2 is going to be the property. It's just severely, severely overgrown. Exhibit 3 is going to be the prior order, which would make it a repeat violation. Exhibit 4 is going to be the notice of repeat violation and the certified mail receipt, affidavit of posting, notice of hearing, certified mail receipt, and affidavit of posting. Exhibit 5 is going to be the property appraiser and the tax collector. Exhibit 6 is going to be the affidavit of prosecution and investigative costs. And I was out there again just prior to the hearing. Nothing has been done on the property, and I have not heard from the owners at all.
Did they pay their fines in previous?
I was going to ask, I don't see it in your code. You don't have anything in there for like lot mow liens, any type of lot mow lien ordinance, or?
Yeah, we do.
We're not doing a lot mow on them at this time.
Oh, okay, gotcha.
Yeah.
I move in case 23-8000032 to find the respondent Stanley J. Caveros and Demetrios P. Caveros as repeat violators in violation of the City of Tarpon Springs Code of Ordinances, Section -840 and 8-52 for the property located at parcel number 12-27-15674-000-0070 Tarpon Springs, Florida 34689. And to accept the affidavit of prosecution and investigative costs for the respondents to pay $119.39 and to assess a fine as a repeat violators of $100 per day beginning on February 16th, 2023 until compliance is achieved. And to order the respondent to contact the Code Enforcement Division to arrange re-inspection of the property and to verify compliance with the board's order.
Second.
Roll call, please.
Mr. Ogle?
Yes.
Ms. Eisner?
Yes.
Mr. Rollinson?
Yes.
Mrs. Telliar?
Yes.
Mr. Weeks?
Yes.
Mr. Perfidio?
Aye.
Ms. Wade?
Yes. Nobody to send that to, they'll mail it out to them. Are we to the end of the list?
We are. You have the approval of the minutes.
If we have
minutes.
They sent them to us to review.
We
ahead of
have quite
time.
a few minutes, and I know we're running late. Beginning in August, Bobby, there's not always a mention of who the counsel of record was. I wanted to confirm, I don't think that Mr. Trask was here in October.
No, I believe so.
So let's just confirm that we have the correct, and we missed 1 month with no representation, and I think that was accurately shown, correct?
Or I thought we missed it.
I do not remember well enough each board's member's attendance status.
I have a problem. With October, it's, it has me as absent, but yet in all the other things inside, I'm voting. So that needs to be fixed. I was present for that meeting.
That's, I remembered that one, and is anybody else see a discrepancy in your attendance? Because I did not write them down every time.
I didn't see anything that jumped out at me.
Okay, thank you. I wanted it noted for the record, case number 11 from May, that we imposed a significant fine and the city commission changed that.
Yes.
And it's not in our records anywhere. I also wanted to welcome our,
So on that one, that would actually be in the
Commission meetings.
meeting minutes, because it didn't technically occur at your board. But now it's in this minutes.
I wanted it in there because we worked really hard
Okay.
on that, and then we got the rug dragged out from under us, so.
Understand.
I wanted to welcome you as our new attorney. Thank you very much.
For your help today.
Thank you, absolutely.
The change of procedures that we made when you came aboard, was that in a November meeting? I didn't see it noted in any of the minutes.
Because those minutes have not been prepared for this board, it was in January when y'all looked at those.
Okay, I
and
just
made your
remember we had
decision,
to
so the minutes
clarify
of
it.
January and February have not been presented to you.
Couldn't remember when it was, Bobby, thank you. And what month did you take over?
Myself?
Yes, indeed.
November?
Yes, but my
Okay,
first
I think
hearing
we got
here
all that
was in
part
January.
straight.
September
I
you
didn't
had a
mean to
hurricane,
dominate it,
that's why
those
we
were
don't have
just
a
things I
meeting in
noticed. If
September.
anybody else has some things.
We didn't have a code enforcement officer. That's why we didn't have a meeting. Wasn't it that we didn't have a code enforcement officer at that time? Did we?
Hurricane in September, and we didn't meet.
We skipped a couple, yes.
Yes.
Couple of months.
And then we
Yeah.
were transitioned, this young lady here came aboard, and they were working some things out.
Working on transition stuff. It's very good.
So just to be clear, the two amendments that I heard were to add the name of the attorney and then to change your
Yes.
attendance and voting on the day that you were not here.
No, I was here.
You were
She
here.
has me as absent, but inside I'm
Ah,
voting.
What
So,
month was that?
That October.
October 13th.
All right, thank you.
Did anybody else see anything else? Would you like to make a motion to approve the minutes then, please?
Make a motion to approve the minutes.
Second.
Voice vote, all in favor?
Aye.
Aye.
Any opposed? Thank you. There's no public left to give a comment. Would you like to speak since you're new here?
I just want to thank you all for your patience with me today. I'm just getting to know your board, and hopefully, you know, as we move forward, we'll have a little bit more clarity as I go through your rules of procedure and everything. So thank you very much for having me.
And before we completely close, did we do the request for rehearing number 11? Did we take care of that, or does that need to be in?
No, you haven't. And at this point, just so that everybody's aware, this is dealing with the property that was paved over, I believe it was at our last meeting, that, right.
Yes.
The pavers were, so we have been contacted by their attorney that they're going to be getting a permit to put it back the way it should be. Instead of asking for the rehearing, what I've talked to the board attorney, and our recommendation is to put it on as a status for next month's meeting. In the meantime, we'll be working with them, and the city will determine whether or not we need to really bring this back and do something. If we're not getting the cooperation, then it will be set. They have the right for a rehearing, of course. At that point, the city will determine whether or not we're going to oppose it. So we would just ask that if we could get a motion to put it on next month.
I'll make a motion, put that on next month's agenda.
I'll
Second.
second it.
All in favor?
Aye.
Aye.
Any opposed? Hearing no further business, meeting is adjourned. Thank you.